Hello and welcome to Delhi Law Firm. Today we have brought for you a landmark judgment that has become a milestone not only for the Sikh community but for the entire marriage registration system of India. This is the case Amanjot Singh Chadha versus Union of India, Supreme Court, 4th September 2025. This judgment has finally clarified the mandatory registration under Section 6 of the Anand Marriage Act, 1909, and the responsibilities of all states. Let's understand it deeply and in simple language.
Absolutely. The most remarkable aspect of this judgment is that the Supreme Court clearly held that no individual of any religion or community should face discrimination due to the indifference of the state. The court said that if the law recognizes Anand Karaj as a valid form of marriage, but the state fails to create the machinery to register it, then it amounts to a violation of the constitutional guarantee of equality. The court also said something very powerful. Constitutional promises are honored not merely by granting rights, but by building institutions that make those rights real.
Exactly. This decision reminds us that a marriage certificate is not just a piece of paper. It is the basis of a person's identity, marital status, property rights, inheritance, insurance, housing, the safety of children, and the legal rights of women. Therefore, the Supreme Court held that the non-registration of Anand Karaj marriages amounts to unequal treatment of Sikh citizens. The court noted that even after the 2012 amendment, many states had failed to frame rules, despite Parliament clearly assigning them the duty to create the marriage register, certified extract, and the registration process.
Yes, and this is why the court issued strict directions to 17 states and 7 union territories across India. The court ordered that within 4 months, all states must frame the rules under Section 6, publish them in the Gazette, and place them before the state legislature. Along with that, the court also issued immediate interim directions, stating that until the new rules come into force, Anand Karaj marriages must still be registered and the certificate must clearly mention that the marriage was performed through Anand Karaj. This ensures that no couple is denied a certificate during this transition.
You're explaining it perfectly. The court also clarified Section 6, subsection 5. Once a marriage is registered under the Anand Marriage Act, no authority can demand that the couple must re-register under any other marriage law. This removes a very big burden because in many states, authorities wrongly insisted on a second registration.
There are more significant directions too. Every state must appoint a secretary-level nodal officer within 2 months to address complaints, supervise the process, and ensure that no discrimination occurs anywhere. The central government must prepare model rules within 2 months and send them to all states, and within 6 months, a nationwide compliance report has to be filed. This will create uniformity across India.
The court also gave special state-specific directions, such as for Goa and Sikkim, where constitutional provisions create different procedures. In Goa, the Union of India must first issue a notification before the state frames its rules. In Sikkim, Article 371F requires a distinct legal pathway, and the court respected that framework while ensuring full protection of rights. This balanced approach, respecting federalism while enforcing constitutional rights, is truly noteworthy.
The court also made it clear that no officer can refuse registration of an Anand Karaj marriage merely because the rules have not yet been notified. If any officer refuses, they must give written reasons, open to legal challenge. This offers strong protection to Sikh citizens.
It is important to understand that the effect of this judgment extends beyond the Sikh community. It sends a message that when Parliament grants a right, states must ensure that the right is real in practice, not just on paper. Whether it is marriage registration, inheritance, or certification for government procedures, states must ensure equal access to administrative machinery.
This judgment also reinforces a core message of the Indian Constitution. While respecting religious identity, the state must ensure equal civil rights. Anand Karaj is a religious ceremony, but marriage registration is a civil right. Therefore, administrative inequality based on religious rituals is unconstitutional. The court said the state must neither privilege nor burden a person's faith. This principle is central to India's secular framework.
If we summarize the legal structure, Section 6 mandates that state governments must frame rules, maintain registers, issue certificates, provide documents, and ensure that non-registration does not affect the validity of the marriage. The duty to create these rules lay with the states, yet many remained inactive. The court called this inaction unconstitutional as it violates the right to equality.
That's why the court said uneven access produces unequal outcomes. Meaning, if Punjab provides Anand Karaj registration but another state does not, then it creates unequal citizenship.
Today, thousands of Sikh families struggle after marriage for passports, visas, insurance, inheritance certificates, bank nominations, school admissions, and more because of the absence of a proper certificate. This decision brings immense relief. It also strengthens the legal protection of women who need certificates for maintenance, domestic violence complaints, and matrimonial rights.
What makes this judgment extraordinary is that the court not only identified the problem but also gave solutions with strict timelines. No state can now delay compliance. The central government told must coordinate and issue model rules.
Now what will be the practical impact? First, Anand Karaj marriage registration will now be mandatory in every state. Second, if any authority refuses, a clear legal remedy is available. Third, interstate married couples will benefit greatly. Fourth, uniformity in marriage certification will finally emerge. Fifth, the constitutional rights of Sikh citizens will be fully operational.
At Delhi Law Firm, we regularly handle cases involving marriage registration, rejection of certificates, interstate marriages, validity of religious ceremonies, passport objections, and inheritance disputes. After this judgment, the legal position has become much stronger. If you have any issue related to Anand Karaj, registration delays, passport office objections, or if any officer has rejected your application, your rights are now clearly protected under law.
You can contact us from anywhere in India. Delhi Law Firm handles cases across the country: marriage registration, writ petitions, civil rights, family law, constitutional matters, High Court and Supreme Court litigation. If your documents are withheld or if an officer has wrongly rejected your request, we can provide immediate legal remedies.
Finally, let us remember this judgment is not merely a technical legal order. It is a historic step that strengthens the soul of equality enshrined in the Indian Constitution. If you need a copy of the judgment, notes, a draft petition, or a personalized case strategy, you may contact us anytime. For more information, please visit our website www.delhilawfirm.news. Delhi Law Firm handles cases across India, and you can reach us from any state.